Hello to everyone. Good evening to everyone. My name is Rahime Erbaş. I am an assistant professor at the University of Istanbul and Law Faculty. I will be moderator for this session. I would also like to thank you all for joining us today, this evening. This session will be conducted by myself and my distinctive colleagues. I will introduce them by name, their country and experience. Our first speaker is Professor Gordana Gasmi. She is from Serbia. Professor Gasmi is a full professor at the University Union Nikola Tesla and a research associate in the Institute of Comparative Law Belgrade in Serbia. She is one of the authors of the Istanbul Convention on behalf of Serbia. Before its ratification in Serbia, she also written a legal commentary regarding Istanbul Convention for the government of Serbia. Under an EU program, she is also a trainer on gender issue and especially gender-based violence for judiciary, police and social workers in various countries, including such as Turkey, Georgia, North Macedonia, and Tunisia. And Professor Gasmi, microphone is yours.
Thank you very much for this kind announcement, dear colleague Rahime, and it's my great honor to speak about the Istanbul Convention at the event organized by the Law Faculty of Istanbul University, especially on the occasion of International Women's Day. And also many thanks for this invitation to the organizers. Today we are marking also almost 10 years since signing of the Convention of Istanbul. And also, as you said, I am the author of, one of the authors since I was a member of the CAVIO committee of the Council of Europe Expert Committee. So it is important to say that in May 2011, on the session of the Council of Committee of Ministers, it was the beginning of the ratification process and also signing of the new convention. So I'm very glad that Turkey was the first member state of the Council of Europe that ratified convention. Today we have 34 countries. And also in 2017, European Union as an entity has signed it. So actually convention is widely accepted and titled as Istanbul Convention as a sign of gratitude for the support of Turkey for its ratification. I would like to say in Rome, we celebrated the entering into force on 1st of August 2014. It was actually done by 10 countries, 8 of them, of course, members of the Council of Europe. So what is the new? Actually, it's considered to be a breakthrough in international law, since actually the convention established legally binding obligations for the comprehensive response to all forms of violence against women, of course, including domestic violence. Even some international NGOs, some like Amnesty International, especially said that the convention made a legally breakthrough because it established European standards on violence against women and domestic violence on the basis of the concept of 3P. It's prevention of violence against women and domestic violence, protection of victims, punishment of perpetrators, and coordinated or integrated policies. It is important to say that the convention also is applied to all other victims of domestic violence, such as elderly people, men and children. But empirical facts show the focus is primarily on violence against women, since 9 of 10 victims of domestic violence are women and girls. That's why the emphasis is on the prevention and fight against violence towards women. And what is important to say that this kind of violence is defined as a severe discrimination against women and the violation of women's human rights. This means that actually we have established the principle of due diligence, which means that states are held responsible if they do not respond adequately to such violence. So under international law, state is responsible for the commission of wrongful acts, which is attributable to it through the conduct of their agents, such as police, immigration officials, and prison officers. So in Article 5 of the Convention, we can see also negative and positive dimension of this state obligation to inform that the state must refrain from the acts of violence against women, and also it must show due diligence in relation to acts covered by the scope of the Convention, perpetrators by its actions and by its actors. So in both cases, failure to do so will incur state responsibility. What is very important considering European standards in criminal justice response to violence against women, it's contained in Chapter 6 of the Convention, with a variety of measures related to investigation, prosecution, procedural law, and the protection against all forms of violence covered by the scope of the Convention. So I have chosen the Article 49 because it contains general obligations, meaning that all states parties of the Convention must take, or actually are invited to take, the necessary legislative and other measures to ensure that investigations and judicial proceedings in relation to all forms of violence covered by the scope of the Convention are carried out. This is actually, I have to emphasize, without undue delay. Of course, while taking into consideration the rights of the victim during all stages of criminal proceedings. And also, this is very important to have a consideration of fundamental principles of human rights and gender understanding of violence to ensure effective investigation and prosecution of offenses established in accordance with this convention. What does this mean, effective investigation and prosecutions? Actually, this means establishing relevant facts, interviewing all available witnesses, and conducting forensic examinations based on multidisciplinary approach using state-of-the-art criminal investigative methodology to ensure comprehensive analysis of the case. And very important also that all investigations and procedures are to be carried out in conformity with fundamental principles of human rights and with regard to gender understanding of violence. So this is especially important, taking account the consideration of Article 6 of European Convention of Human Rights. What does this mean, prosecution, in terms of criminal justice response? First of all, violence against women is criminalized and appropriately punished. Excuses on the grounds of honor are unacceptable. Victims have access to special protection measures. Law enforcement agencies respond immediately to calls for assistance and manage dangerous situations adequately. What offenses are included into the convention? All kinds of domestic violence, even including psychological and economic violence. Stalking, sexual violence, including rape, sexual harassment, forced marriage, female genital mutilation, forced abortion, and forced sterilization. It is very important to leave possibility to have a much stronger sentence on the perpetrator when the victim is a spouse or member of family or a partner, because those offenses are not private matters. This is what Convention said, seeking for zero tolerance in all societies towards all forms of mentioned violence. What about law enforcement and judicial proceedings? Effective police investigation, effective public prosecution, which means that it will not be dependent upon a report or complaint by victim, and may even continue if the victim withdraws their statements, which actually occurs very often. Consideration of aggravating circumstances, then legislation criminalizing violence against women, dissuasive sanctions for perpetrators, and a very important process of risk assessments, which is based on multi-agency approach and taking into account access to firearms. Then protection of child victims and witnesses, especially leaving a possibility to initiate legal action for a sufficient amount of time after they have reached adulthood. In cases of very severe offenses. Then no victim blaming investigations. And finally, victims' protection during investigation and judicial proceedings in order to avoid the secondary victimization. I have to say that this convention is not only based on the words of the paper, which means actually like tiger without teeth. On the contrary, we actually have established monitoring mechanism and not to mention series of trainings throughout the Europe and Asia and Africa in terms of implementation and proper legislative reforms. But this monitoring mechanism is based on two pillars, and which is very important to have a very active Gravio expert body and also committee of the parties as political body with the inclusion of national parliaments with a parliamentary network of Europe. So I can say that this is also very important. And my second part of the expose, I would like to respond to some matters that my colleague Rahime sent me as a kind reminder what is useful to say about my country. In my country, we have started to celebrate International Women's Day since 1914. And today it's widely promoted and it's been put under constitutional principle of gender equality and policy of equal opportunities. So it is still very widely marked. As for the second matter that my colleague Rahime asked about Serbia, actually Serbia ratified the Istanbul Convention in November 2013, and it entered into force also on 1st of August 2014. So we have one reservation that has been renovated as of last year till 2025 concerning Article 30 about the compensation to the victims of the violence, since the state does not have available official records of the court files against perpetrators. So that was the explanation while it is renovated. And we also canceled the reservation in respect of the Article 44. So many national expert conferences were held targeted to promotion of the Istanbul Convention. And I have to say that I also participated in trainings of judges and prosecutors, so it is widely accepted and implemented in judiciary. About the third question, which is also very important, and thank you, Rahime, that you mentioned the legislative reforms. We got the Gravio report on Serbia, which is rather very positive and actually welcomed clear policy commitment to eliminate gender-based violence, and that progress is made in adapting response of the state to violence against women according to international standards. So the central legislation that has been born is the law on the prevention of domestic violence, as a central piece of legislation that helped very much in handling individual cases of domestic violence. And that's how much effort has been put in its implementations. So very positive changes have been achieved since 2017. And also since 2016, we made several amendments to criminal code. So we have introduced the new offenses of stalking, of sexual harassment, of genital female mutilation, and forced marriage. And I have to say that however, the criminal offense of rape is not defined as a sexual act that the victim is not consent to, as it is required by the Istanbul Convention, but it is still defined as an act committed with the use of force, coercion, or threat. So this is criticized by national NGOs and also in Grevio report. What I also have to say that conviction rate for most forms of violence against women are extremely low. The reasons therefore range from low levels of reporting, also because of lack of guidance how to build a case, and the insufficient training, especially for newly introduced offenses like stalking, and very difficult to give proofs for psychological violence. And about the online violence, which is extremely interesting question, we can discuss after also. And again, thank you, Rahime, that you, and to the organizers that you sent. It's been dealt by the offense of stalking and by the offense of sexual harassment. So since 1st of June 2017, we do not have so many cases, but I have some interesting comments by public prosecutors and judges, so we can share it afterwards. And I would like to say also that we have introduced in special article, the exploitation of a computer network or communication by other technical means for the commission of criminal offenses and against sexual freedom against a minor, which is also very important, since very often girls are unfortunately the object of such violence. So I think I managed to respect 15 minutes. So thank you for your patience, and again for the invitation. Thank you.
Thank you so much, Professor Gasmi. It was an excellent presentation. I personally enjoyed a lot, and your experience is also very unique. When we met in Romania, you explained more about this. And in the question and answer, we can discuss more. And now I would like to introduce my our second speaker, from Chara Chioni-Chotouman from Greece. She's a PhD candidate in the Department of Criminal Law and Criminal Procedure at the National and Kapodistrian University of Athens Law Faculty. Her PhD topic is victim rights in the criminal procedure, for which she also received a full scholarship for State Institute for Scholarship. Also, right now she is working as a lawyer at an NGO called Diotimo. This is an NGO providing legal advice and representation for the victims of gender-based violence and conducting trainings on this issue. She has also, Chara also has published several articles in English and also in Greek. and delivered speeches both in Greece and abroad. She speaks Greek, English, French, and German. And now, Chara, microphone is yours.
Thank you very much, Rahime. I would like to thank Istanbul University for your interest in the subject, and of course, Professor Adam Sozwer for its kind invitation and your invitation, and all the other speakers being here for this really important day for women. I would like to, today, I'm gonna just pick up from where Professor Gasmi started. And we're going to talk about positive obligations and the offense of rape. So everything you heard will be really valuable. So when we're talking about positive obligations, we should have in mind that for member states of Council of Europe, it's the Istanbul Convention, the first pool of positive obligation, and of course the European Convention of Human Rights as interpreted in the case law of the European Court of Human Rights. So first of all, we have the Istanbul Convention. For the offense of rape, we do have Article 36. I just remind you that the Istanbul Convention is signed by all Council of Europe member states except Azerbaijan and Russia, and ratified by 34 member states. So going to Article 36, we see that Istanbul Convention actually adopted a really broad conception of rape. So we read that parties shall take the necessary legislative or other measures to ensure that the following intentional conducts are criminalized. First of all, we have non-consensual penetrative sex. We also have non-consensual sexual acts of more broad natures, so not only penetrative sex, but also other aspects of sexual behavior shall be criminalized. And last but not least, non-consensual acts of a sexual nature with a third person. So we see here that we have a very broad, conception of rape. So there is also an obligation to punish acts committed against former or current spouses or partners. This is particularly important. Just keep in mind that in Greece, till 2006, intermarital rape was not an offense. This is not so far away from us now. It's actually 15 years ago that intermarital rape was not an offense. So this is pretty important. However, we do have some retrogressive tendencies in some countries, for example, Poland and Turkey, that might compromise this all this thing that we achieved with the Istanbul Convention. So, except the Istanbul Convention, however, for the offense of rape, we also have the European Convention of Human Rights. According to the case law of the European Court of Human Rights, in the field of substantive criminal law, the member states are obliged to take adequate positive measures in the sphere of criminal law by enacting criminal law provisions. This is not for all the offenses, but it is for rape and serious sexual assaults. Here I have a case for you. What is also really important is this relatively new case, the Z versus Bulgaria, where we read that the contracting state's positive obligations under Article 3 of the Convention must be seen as requiring the penalization and effective prosecution of any non-consensual sexual act, including in the absence of physical resistance by the victim. So it's not only the Istanbul Convention, but now it's also the European Court of Human Rights that states that member states shall have a broad conception of rape, including non-consensual sexual acts. I'm now gonna speak a little bit about Greece. Greece has a very broad definition of rape, just like Sweden. This was not meant to happen. It happened in 2019. It's a really long and interesting story. But they actually, in 2019, there was an effort to actually narrow the scope of rape. There was an outcry that led to a last-minute amendment by which non-consensual sexual acts constitute rape. So in Greece, we did have let's say this, I have a same for you. There are 3 types of rape provision. The non-consensual rape, which is a felony entailing imprisonment of 5 to 10 years. Rape by the use of physical force or threats related to life or physical integrity, something like in Serbia, Professor Gasmi stated, which is imprisonment 10 to 15 years, and of course, aggravated forms of rape. So Greece, yes, has non-consensual rape. However, there are some academics that state that this is not really going to work. There are voices against this development. So it is not really established, not even in the academia. We're going to have to work a lot on this notion of consent. And I think it's something that will all member state academics will have to face eventually. But we do have it, and this is really a development for Greece. Last but not least, I would like to talk a little bit about the Istanbul Convention here in Greece. Greece ratified the convention in 2018 with a law then. There were significant amendments. I'm going to just state the most important ones, which was the introduction of the offense of stalking and the offense of female genital mutilation. And what also was really important was the fact that non-cohabiting partners were included in the special statute for domestic abuse, because back then, non-cohabiting partners were not considered as a family. However, there are several shortcomings, and there are several shortcomings, especially regarding online violence against women. In Greece, there is not a specific offense for what we call revenge pornography or image-based abuse. We deal with those issues in the framework of privacy rights, privacy data violation, maybe threat, maybe stalking if it's something that actually happens. But of course, this is not the appropriate way to deal with those kind of this kind of behavior. There are also issues with online abuse committed via applications. We see that we have issues gathering of evidence and go through the anonymity of the perpetrators. So there are a lot of things to do there. I will end here. I would like to really engage with a vivid discussion with you all, and thank you very much for the invitation.
Thank you. We thank you, Chara. It is also, I enjoy a lot, and it is also very interesting and very focused. This rape issue, especially in terms of Istanbul Convention, also it requires that also have to criminalize marital rape. Also, it's also very important. And you just show us adaptation of Greece law in terms as an example. Thank you so much. I think it's a great example for us. Now, I would like to introduce my third speaker from Spain, Raquel Borges Blázquez. Dr. Blázquez is right now assistant professor at the University of Valencia. Her research focus are mainly protection of victims in the criminal procedure, and also she works on the use of artificial intelligence for the justice system. She also carry out research stay in abroad, especially in Max Planck Institute in Freiburg, also in the European Agency for Fundamental Rights, and also Max Planck Institute in Heidelberg. Now, Raquel, word is yours.
Okay. Can you see my slide?
Perfect. Yeah, yes, perfect.
So, first of all, I would like to thank the organization for inviting me, because it is such an honor for me to be here today.
Just a second, Raquel, your voice is not good quality. I mean, it is not so good, not so much hearable.
One moment. Okay, now it's better.
Yeah, if you could a little bit speak a little bit loud, it will be great.
Perfect. So sorry for the inconvenience. First of all, I would like to thank the organization for inviting me because it is such an honor for me to be here today. My contribution summarizes with an example the necessity to continue creating a real European Union in judicial cooperation issues. During the next 15 minutes, we are going to see how the transnational protection of gender violence victims works in practice. The instrument I am going to discuss is the European Protection Order. Firstly, we have to take into account that there is no single definition of what a protection order is. Therefore,
Raquel, just a second. We can hear your voice, but if you could speak a little, loud, but a little slowly. So, could you try again?
Okay. So, the instrument I am going to discuss is the European Protection Order. Firstly, we have to take into account that there is no single definition of what a protection order is. Depending on the country, protection orders can be criminal, like in Spain, civil, like in Germany, or even administrative, like, for example, some kinds of protection orders that we can find in Ireland. The European legislator was aware of this reality and created two instruments, one in 2011 for the criminal matters and one regulation in 2013 for the civil one, and both came into force in 2015. During this presentation, we are going to see how the European protection measures work in practice. We will have two examples. One that starts in Spain, asking for a criminal protection order according to Spanish legislation and the directive on the European Protection Order, and the second one that starts in Germany, asking for a civil protection according to German legislation and regulation on mutual recognition of civil measures. But before, we need to answer three previous questions. First one, who is going to be the competent court to issue the protection measures? There is a need for an existing protection measure under national law in order to issue a European protection order or a certificate in civil matters. European protection measures are subsidiaries from the national protection measures. The protection measure must be issued by the country where the unlawful act was committed. Secondly, what do I have to do when I arrive to the foreign country? The answer to this question depends on what kind of national protection measure we have. If it's a criminal measure, the competent authorities will be the ones to communicate between them. The European Protection Order is a communication judge to judge. But if it is a civil measure, the victim will be the one who will have to submit a certificate to the competent authorities. Last but not least, which measures can be recognized? Only three measures can be recognized because these three measures can be found in almost all European Union member states. These are to not communicate with the victim, to be banned from visiting certain places, and to keep a safe distance from his or her victim or family and friends. Let's start with the first practical case. Let's say that I am a victim of intimate partner violence in my hometown, Valencia, and at some point I have a long-term relationship with a man, and at some point I decide to split with my boyfriend. And this is the moment when he doesn't accept my decision and starts stalking me, not only electronically via Facebook and phone calls, but also physically. And this is why I decide to ask for a Spanish protection order. Within the Spanish law, as long as I am a woman and the violence is committed by a man who was my partner, this case should be considered a gender violence case. That is why I should go to a criminal court, which in the Spanish legislation is called Juzgado de Violencia sobre la Mujer. The translation into English should be Violence Against Women Court. And in the Violence Against Women Court, I will have to ask for my protection order. After having my national protection order, I decide that I don't want to stay more time in Valencia and I need some fresh air in order to forget all this experience. And this is why, let's say, I decide to move to Freiburg to a postdoctoral research. And here comes the transnational element. It turns out that I have been there before doing a predoctoral research, and my ex-boyfriend came to visit me. So we do have to assess the risk of him following me. He knows where I am going to live, where I am going to work, which are my favorite cities in the places, and which are the restaurants where I normally go. That is why when I asked the Spanish judge for a European protection order, taking all these elements into account, he assesses that I have enough risk in order to ask for a European protection order and decided to issue one. Now we need to know who is going to be the competent court in Germany. So we are going to check in the European Judicial Network. As you can see in the slide, he just has to check on the Judicial Atlas which measures he wants to issue and to which country is going to send it. When we check the European protection order in Germany, it says work in progress, because nowadays there is no available data about this topic in Germany. But even if the information is not available in the Atlas, there is no problem because it redirects us to the Fiches Belges. When we check Germany in the Fiches Belges, we realize that the competent court is the family court in whose jurisdiction the protected person resides. In this case, it will be a family court in Freiburg. It is also important to check which are going to be the languages that German courts will accept when we issue a European protection order, because the Spanish competent authority will have to issue the European protection order in one of the affected languages of the executing state. In this case, Germany does only accept German language. So the Spanish competent authority will have to translate the European protection order into German in order to send it to Germany. Now we are going to reverse the example. I am a Spanish researcher that is working in Freiburg, and at some point I start a relationship with a German man. We are passing through that time because I want to come back to Spain and we don't know which is going to be the future of the relationship. And this is why he starts to mistreat me and I decide to ask for a protection order. This time, according to the German law, the protection order is going to be a civil measure and it's going to be issued by a family court. But again, we have the same problem. When I move back home, I won't have protection. This is why this time I will have to ask for a civil certificate in order to continue maintaining the protection also in Spain. This time, the German judge should search for the competent authority in the European Judicial Network in civil and commercial matters. When we search for the competent authority for enforcement in Spain, we find that it's called Juzgado Decano Exclusivo de Valencia. With all this information, the German judge will give me a paper containing my civil certificate. This time, he's not going to send the certificate to the Spanish authority. It will be me, the one that when I arrive to Spain, I will have to assess my risk and decide if I want to activate my European protection measure or if I don't want. Even more, the German competent authority is not going to care if I activate or not my protection measure, because in this time we are not using criminal we are not using a criminal protection, but a civil one. Only one more question to conclude. Why ask for a European protection measure? We already have national measures. So the question is, do we really need this European protection measure? I think so. In a globalized society where people travel abroad for jobs or doing tourism, I think that we cannot continue maintaining a protection only at a national level. I am not the head of the sample, but according to the Fundamental Rights Agency data, 1 from each 4 European women has suffered some kind of violence from her partner or ex-partner. Being able to ask for a European protection measure will not only reduce the judicial bureaucracy and its costs, but it will also benefit the victim due to the fact that she won't have to initiate a new judicial procedure in a foreign country. This is why I strongly recommend to continue researching in this topic in order to continue protecting gender violence victims. Thank you very much for your attention.
Thank you, Raquel. Although there is a problem, but we could hear you. And this is also a very interesting topic. Although Turkey and my colleague from Serbia, we are not yet European Union member now. We have not so much this kind of problem, not yet. Maybe in the future. But also it is very interesting. A judicial cooperation between the countries. In terms of this protective measure, your speech is very interesting. And did you yourself take photo before the Max Planck? Is that Carl, which you married? Not yet.
I was the one who made that picture like 3 years ago, yes.
Oh, thank you, Raquel. It is very interesting. Thank you so much. And now we have fourth speaker. She is also from Spain, Cristina Ruiz López. Dr. López is a professor of procedural law, criminal procedural law at the University of Burgos. Her doctoral topic was procedural rights of victims of gender-based violence against women in the European Union. In 2019, Dr. López has a research stay in the International Victimology Institute, Tilburg. Also, she has participated in 6 projects, 2 European, 1 national, 1 regional, and 1 by Third Carlos University, Madrid. She is also coordinator of the blended learning modality of Master in Mediation, Negotiation, and Conflict Resolution at Third Carlos University of Madrid from 2011 to the present. Also, Dr. López is a member of the research group, Civil and Criminal Judicial Cooperation in the European Union, procedural instrument led by Professor Mar Jimeno Bulnes. Since 2011, she is also a member of the Bar Association of Madrid. And Dr. López, words are yours.
Okay, I think I'm sharing my, yes. Okay. Well, good afternoon, everyone. I think you can hear me properly. Yes, it's my pleasure and my honor being with all of you today. And first of all, I would like to thank to the organizers, especially Rahime Erbash, for this great opportunity to participate in this event and for this kind of introduction. Also to my colleague Raquel Borges for sharing with me the information. I really appreciate the celebration of this online event in this historical day. In my presentation this afternoon, I will try to expose, this evening, I will try to expose the need to examine the victims' procedural rights with a gender perspective in order to ensure its effectiveness to women victims of gender violence, gender-based violence. Okay. Because of the limit of the time, I will focus on 2 of the procedural rights recognized in the European Union, but including the considerations in Istanbul Convention and the group of experts on action against violence against women and domestic violence. These 2 procedural rights are the right to understand and the right to be understood. As an introduction, it's necessary to say that this main subject is integrated by 3 topics interrelated: procedural rights, victimology, and violence against women. 3 topics which can be analyzed in many different disciplines: law, history, psychology, sociology, philosophy, social sciences, humanity, economy, with different perspectives and with applying different investigation methods. Therefore, analyzing the procedural rights of victims of gender-based violence is a huge challenge. Some brief considerations should be noted in these three topics. In relation to procedural rights, we have to take into account that are rights in the framework of a process, but also it should be highlighted that the right to understand and to be understood can be placed before the criminal proceeding, for instance, in the police station. The right to be understood will have an essential role if we pay attention to the importance of some principles in the criminal process, such as the principle of equality of arms, adversarial proceedings, and the principle of immediacy. Besides, it must be stressed that the regulation of the criminal procedural law depends on each state, but it's also influenced by European regulation, Council of Europe, and European Union, and with a control by the European Court. Regarding to victimology, I would like to highlight that the consideration of women as human rights holders is a recent achievement, consequence of a very long historical reivindications by many women and some men, the importance of the feminism movement and feminist theory. But also, it's an important and incomplete way, being jeopardized every single day with the need to recognize the human rights of the woman de lege and to ensure them de facto. In relation to violence against women, the most violent expression of the discrimination against women, we follow the definition by Istanbul Convention. The violence against women is a worldwide situation of women whose origin, causes, consequences have been explained yet. This importance of the genealogy, our predecessors, should be reminded. We cannot discover again the Mediterranean Sea. We are following a traveled way, but still a long way to go. Having said these previous ideas, we can analyze the procedural rights named in the title. Regarding to the right to understand and to be understood, the victim's right is recognized essentially in Article 3 of Directive 2012-29 European Union, and we can say that is recognized indirectly in Articles 21 and 49 of Council of Europe Istanbul Convention. These two rights are the core rights for the application of the other procedural rights because it's necessary to do an individual assessment of individual interests of victims, needs and situation in order to ensure the other procedural rights, information, translation, interpretation, to be heard, to make a complaint, protection of privacy, telephone helplines, etc. What can it be said with a gender perspective? If we read Article 3, Directive 2012-29, it can be highlighted three positive considerations from a gender perspective. The first one, from the first contact and during any further necessary interaction. Why is it important from a gender perspective? Well, if we focus on victims of sexual crimes, one of the conclusions of a European project I'm collaborating with called Retreat is that this first moment after the crime is when the greatest neglect of victims' interests and the most serious violation of their rights take place. The report and executive summary of this project will be publicly available soon on this website you can see on the slide. In fact, in Article 25, Istanbul Convention is especially referred to this kind of victims. You can visit the website indicated in this PowerPoint presentation, and also it's available the Spanish version of the report in SSNRN. You can see the screenshot. The English version will be available very soon. Also, in Article 24, Istanbul Convention is regulated the availability of telephone helplines giving information about all forms of violence covered by the scope of this convention. In Spain, there is a helpline 016 available 24 hours every single day of the year. So it's essential from a gender perspective an integrated analysis of both European instruments, Directive 2012 and Istanbul Convention. The second positive consideration in this article from gender mainstreaming is recognized in paragraph 2 to take into account the personal characteristic of the victim. One of the main ideas regarding the concept of gender mainstreaming stressed by Council of Europe is that women and men are not homogeneous groups with single aims and needs. It's necessary to take into account women and men's multiple identities in terms of age, ethnicity, sexual orientation, gender identity, social status, or disability, to name a few of characteristics. This provision is also connected with Article 83 Istanbul Convention, address the specific needs of vulnerable persons, including child victims, and be made available to them. And with Article 22 Istanbul Convention, specialist support services, with a very important reference to adequate geographical distribution, especially important because of the specific and more vulnerable situation of women living in rural areas. In Spain, as a consequence of the state pact on gender-based violence agreed by all the political parties in 2017, the Ministry of Equality has recently presented a very interesting report about this type of victims of violence against women. But also there are other reports on specific women victims, such as the situation of violence against women in adolescence in Spain, sexual violence against women with intellectual disabilities, women disabilities and gender-based violence, or the study on women over 65 years of age who are victims of gender-based violence, published in 2019. All these reports offer a very important information and proposals, which it has been positive stressed by the group of experts review. The third positive consideration from a gender perspective, when gender mainstreaming, is the possibility that the victim can be accompanied by a person of their choice. A long distance request by victims being alone in front of different professionals asking her question about a very intimate facts can be deterrent to report a crime. In order to make real this right and the right to not see the perpetrator, a specific space in the judicial buildings has to be built. This is not a general situation because of economic grounds. Well, despite all these positive considerations, there are some concerns in this article that can be stressed. On the one hand, the main debility of this article, also highlighted by the European Institute for Gender Equality, is the lack of clarity. In fact, what does it mean to understand? And perhaps more important, under what kind of circumstances can it be said that someone has understood something? And what kind of consequence derives to the fact of have not understood? Victims also have the right not only to understand this information, but also to know the repercussions of their decisions, which therefore must be part of the information provided to them. Understanding what legal, procedural, labor or social consequences their decision will unfold. It will help them to exercise or not exercise their rights in a conscious and responsible manner. However, at this point, we could differentiate between understanding that a right is recognized, and the other thing, assessing its exercise. This brings us to the psychological and sociological aspects of the victims of gender-based violence against women. In this regard, we should not separate the psychological element of the victims from the legal aspect. An apparently neutral wording of the law can have an important negative consequences as a consequence of the indirect discrimination it generates, derived from the socialization of gender roles and stereotypes. For this reason, establishing a right to understand without taking into account the psychological state that causes the situation of violence experience means recognizing a right that will not be exercised by a person who suffers such a crime. The Handbook on European Law relating to access to justice by European Union and the Council of Europe has identified fear and embarrassment, lack of knowledge of official processes and available assistance, restrictions on the availability of legal aid, economic dependence and concern for children, and the gender impact of austerity measures as the main socioeconomic obstacle to women's access to courts. Legal obstacles include the persistence of de jure discrimination against women, gaps in women's rights legislation, limited use of anti-discrimination legislation on the basis of sex, gender neutral or gender blind legislation that allows for systematic sometimes intended inequalities, limited use of international standards on judicial decision, limited remedies for indirect discrimination against women, emphasizes on the use of court settlement procedures that sometimes disadvantage women, as low criminal proceedings, corruption, and low levels of trust, discriminatory practices, negative gender stereotypes in the judiciary and the policy. The same report points out some good practices in some states, parties such as specialized courts like in Spain, and fast-track procedures, specialized prosecution, or a specific police unit. Review and the group of experts on this report on the implementation of Istanbul Convention in Spain encouraged the Spanish authorities to strengthen their efforts to provide information to victims of all forms of violence against women in a format and language they understood, number 114. In this aspect in Spain, a new organic law for the integral guarantee of sexual freedom is being prepared. The lack of clarity also is projected to the measures to be adopted by the member states and the specific training that the professionals must have. And what should it mean by unless contrary to the interests of the victim or unless the course of proceedings will be prejudiced. Being accompanied is always a good option for the victim. If we consider that many crimes of violence against women are committed by boyfriends, husbands, relatives, and some trusted people by the victims, it must be welcome the warning contained in this third paragraph, unless contrary to the interest of the victim or unless the course of proceedings will be prejudiced. For instance, regarding to the crime of forced marriage, we have the result of an interesting project on the crime of forced marriage, EU roadmap on forced early marriage, referral pathway for frontline professionals. Specifically, it recommends 6 measures in this moment can be highlighted. Conduct interrogations without the presence of family members of people from the environment to avoid any possible pursuit of the victim. In the case of minor victims, conduct interrogation only in the presence of a professional from the Child Protection Office. If the victim is female police and interpreters should definitely be involved because many victims, when interrogated by men or even in the presence of male police or interpreters, do not tell their whole story. In this context, we can imagine the transcendental role of the professionals and their training on gender perspective. In this regard, we can ask ourselves whether the professionals who are in contact with the victims receive training in, among other aspects, communications. The answer is affirmative in the case of judges, as shown in the Commission communication in the section entitled Availability of Training for Judges on Communication with Parties and the Press. In Spain, as a consequence of the ratification of Istanbul Convention in 2014, a state path on gender-based violence has supposed many modifications in this Spanish legal system. For instance, the organic law on judiciary now provides that all selection tests for admission and promoting within the judiciary or the state prosecutor's office should incorporate a study on the principle of equality between women and men and measures designed to combat violence against women. However, Review, the group of experts on this report on the implementation of Istanbul Convention in Spain, stresses that while recognizing the training for judiciary is legally mandated, Review strongly encourages the Spanish authorities to evaluate the different training available to the judiciary in order to improve its impact. Review urges the authorities to ensure that the available training addresses all forms of violence against women covered by Istanbul Convention, in particular sexual violence, as well as the psychological dynamics for intimate partner violence, post-separation violence, the effects of violence on child victims and witnesses, and the prevention of secondary victimization, number 19.8. To sum up, to ensure the effectiveness of procedural rights is necessary not only classify, criminalize in the criminal code this act as a crime, but also having into account the different material circumstances of the different victims. The socialization on gender role plays a transcendental role in the experience of being a victim, to the idea to be understood and to the ability or capacity to understand. Because of that, the Directive 2012-29 European Union must be analyzed along with Istanbul Convention, together with Istanbul Convention and with a gender perspective. In Spain, review highlights that many positive actions and modifications have been implemented, but it also be improved other, such as improving coordination between administration, improving care for women in rural areas, and the need to address all forms of violence against women, eliminating the condition of the existence of a past or present relationship in order to charge a crime of gender-based violence. I'm going to stop here. Thank you for your attention.
Dr. López, many thanks. It was a very comprehensive speech presentation. You show us a direct European Union directive and also Istanbul Convention and also your national law in terms of victims, women victims of domestic violence. It is very significant issue. Also, in some articles, also I read Spanish law has peculiarities in terms of victim protection in the criminal procedure. Therefore, your speech presentation is so available for us. Thank you so much for such a comprehensive presentation. Now we are at the stage of question and answer. We have a couple of questions here. I wrote them down, but as a mediator here, I just want to ask a question, very fundamental question to our colleagues from Serbia, because she was one of the authors of this Istanbul Convention on behalf of Serbia. And why Istanbul Convention is signed in Istanbul? What is the significance of Istanbul in this regard? I remember you explained a little bit in Romania, where we met in 2019.
It was very important that we actually got the inspiration about the principle of due diligence during the sessions, very tiring sessions of CAVIO committee after the judgment of the European Court of Human Rights against Turkey. So it was a negative, let me say, inspiration, but afterwards that was the case of Opus versus Turkey. Actually, it only established the previously already formulated practice, and it was already accepted and it as international customary law, the responsibility of state. But afterwards, during the session, also my colleague from Turkey, she was very active. Also it was symbolic that Turkey expressed the politically very strong intention to ratify the convention right after the signing it. So that was political symbolic, and also I think it was very important, especially after this negative judgment of the European Court. So that was a kind of balance. And I think it's very important to continue with title Istanbul Convention. So I think it is important, but I hope this opposition to the convention will not persist. Maybe it's just my thesis, the argument about the ruining of family structure comes from the ban of alternative mediation of disputes, and which is actually contained in the Article 48. So it is a kind of prevention of prolongation in the course of divorce procedures to have that kind of, it's not pre-trial, but a kind of, let me say, alternative dispute solution. So it's very strongly prohibited by this article of the convention. But the aim of this article was not to ruin the family structure. It was the aim, and it is strongly intended to protect the victims, including children also, of domestic violence, which are very vulnerable groups. So I would say opposite. It's actually protecting the essence of the family solidarity. That's my explanation of maybe misunderstandings. So hopefully I hope that it will not persist in Turkey, this kind of opposition. What do you say, Rahime?
Also, you explain in Romania, one of the most important peculiarities of Istanbul Convention, it is opened all over the world, which is very different in other Council of Europe, European international agreement. So you thought that Turkey as an example can be an example for other Jordan and other countries, yes, because we have a border with Middle East and Asia. So this is, I think, the most important peculiarities of Istanbul Convention. I mean, Istanbul stay as a unit in this regard. It can be example for other world.
Actually, the special, let me say, benefit of the Turkey's ratification is that it can be considered as a success story for other countries also in the region, and even for non-members. So I believe that it would be a very strong damage for the international law and also for the modernization of Turkish legislative system to withdraw. For Poland, we know that it is the influence of church. But for the Turkey, it would be really very, very great damage, and I hope that it will not happen, especially for this nice anniversary we have. Imagine that Turkey ratified Convention the first, and United Kingdom still did not do it. So we can say who is modern, which country is modern. So it's very helpful to have discussions. I think it's always very good to have, but not to withdraw and not to have extremist argumentation in this kind. Like in Croatia, it was also a problem, but they resolved it.
Yeah, regarding also your question, yeah, there are some regression, there are anti-argument against Istanbul Convention, but time to time this argument appear, but the majority of society now adopted Istanbul Convention, claim it as a national law. So I think it is infactual, this discussion from withdrawing Istanbul Convention has lost, I mean, it is impact in Turkey.
So it's finished discussion.
It's finished. This kind of argument appears time to time, but no effect, no factual effect, because majority of society, according to my opinion, majority of society adopt it, accept it. But of course, there are minority opinions and there are populist arguments about it.
It is always difficult, you know, when some country has to reform its legislation and especially judicial practice. For example, in Serbia, we still have problems with definition of rape. And also we still have critics from our NGO sector about the low conviction rates, especially for sexual offenses. And even for stalking and for psychological violence, it's difficult how to give proofs and how to avoid misuses, and for sexual harassment. But I think what we did in Strasbourg, actually, we set standards. So each country has to accommodate to its own, let me say, legislative framework, and of course to go further. So thank you for the question.
We have another couple of questions. The first question. Just a second, I am not good at this technological stuff. We have another question for colleagues from Greece.
Hi, yeah. It's about a special law enforcement agency dealing with implementation of the Istanbul Convention. In Greece, actually, in 2019, we established a special agency in the police department for Athens and Thessaloniki, but only for domestic abuse. They are actually dealing with issues of domestic abuse, so it's not really about the everything about Istanbul Convention, and of course it's not about sexual crimes per se. So yes, we're doing some things over there, but we're not quite there.
And Chara, the other question is about this rape issues, re-victimization of survivors. The second question also, all speaker has a 5 and 6 minutes for each of them. So, Chara, regarding re-victimization.
Yeah, I would like to say that this is a real issue, the re-victimization in this procedure, and it's also an issue for the victim and for the offender. In Greece, we do have really lengthy procedures, and for the offense of rape, we could see a proceeding lasting approximately 10 years. This is really traumatic for everyone, for the society as well. So we should keep in mind that member states should work to actually build special proceedings for sexual offenses. We here in Greece also have issues with, as Professor Gasmi said, with building a case, with having the evidence gathered, and we must keep in mind that when the first hearing is in 5 years from the time the offense was committed, it's really hard to keep evidence and for the victim to be able to relieve everything that happened. So we should work for not only having a special statute, but also having special procedure and be able to deal with it effectively, and also having in mind that police enforcement must be capable of being there for the victim, because here in Greece we had a lot of cases when police officers actually said to victims of domestic abuse that they should not file a complaint, they should think about their kids and their family. And this is something that's happening a lot, not only in other regions of Greece, but also in Athens. So it's also something that we should keep in mind, that there's victimization of survivors in the penal proceedings before the court, but also in police stations, but also in hospitals where they're going and seeking help. So it's a widespread problem. Thank you very much for the question.
Yeah. And I would like to take opinion all of the speaker regarding this question. And Chara, if there is nothing to you express about the other question, I just want to turn the other speaker. Thank you. And also you answer the question whether there is a anti-movement against the Istanbul Convention. Now, currently there is no in Greece. You answer. So then I can
say we don't have any anti-movements. We have only problems in practice with trials considering stalking and sexual harassment. Actually, I talked with, for example, public prosecutor, a deputy, and he said that we still have no large number of charges in those cases, but the problem is very difficult how morally from sexually immoral behavior will be distinguished in practice. So this is what has to be proved by evidence, by also statements, witnesses, and if one side does not feel comfortable, he said it put it, and then the other side didn't accept that, so we can talk about sexual harassment. So this is rather new also in our traditional judicial proceedings. And as for stalking, unlike sexual harassment, the crime does not have to have any emotional or sexual connotation. So actually what is important, and he said when it goes via social networking, it means that just monitoring a certain person is not stalking, but it is necessary to prove that the goal was to physical approach to that person. So it's not a matter how many messages it sent, but however, police has very good cooperation with the internet companies and can give some proofs. So we have also numbers for victims of violence, and also number of our national NGO, Autonomous Female Center. So that's a kind of, let me say, practical difficulties, but for emergency bearing orders, it's already very well established since 2017. And we have very good trainings of police. So, but still the problem is that the number of victims are high, very high, especially femicides. So that's the problem, but it's not because of raising and because of the new law. It is actually the how to say, courage of victims to report it to police and also to centers of social work. So that's from my side.
Thank you, Professor Gasmi. And as colleagues from Spain, would you like to express, you can also, both from Spain, you can also share a question. Would you like to express something, some thoughts regarding this question? Raquel and Cristina?
Okay, maybe I start and then Cristina can add something to my explanation. I think that we in Spain, we didn't have problems implementing the Istanbul Convention because we already protected the victims and we already had these crimes in our criminal code. One of the most important things I see about the Istanbul Convention is that for us, before the Istanbul Convention, we had a really different kind of definition of what a gender violence victim is. According to the UN, a gender violence victim is a woman that can suffer women from any kind of men because of gender reasons. But within Spanish legislation, we just decided that gender violence victims were the ones who suffer violence from her partner or ex-partner. So for us, gender violence victims were only the ones who suffer gender violence, but inside the couple. So at some point, we have a definition between domestic and gender violence. So one of the most important things that I see about the Istanbul Convention is that nowadays, when we have to count the women that each year die because of gender violence, that are more or less 60 per year, we have to include also not only these 60 women that die because her partner or ex-partner ended with their life, but also another women that have suffered another kind of violence against women because the fact of being women, for example, raped by a stranger, killed by a stranger because of the fact of being women, that before of this Istanbul Convention, they didn't have like this status of gender violence victims that nowadays they have. But the really expert in gender victims is Cristina, so now she can continue explaining about this topic.
Okay,
Now,
thank you, Raquel. Yeah, Cristina.
sorry. Now, just I would like to add only that in Spain, as Raquel said, we don't have any huge problem in implementation of Istanbul Convention. I think that the sensibility of Spanish society is very high in this current time. I only want to differentiate two spheres. The one is related to the legal spheres that I think in Spain is very, very good, and in relating to the other countries in the European Union and Council of Europe. But we have to improve in the spheres related to the practices. For example, regarding to victims of sexual crimes, we have to improve our legislation and practices related to the protocols in different professional areas, and also related to the concept of consent. And we have now a very debate related to this concept with a new possible legislation law, and with the need to implement like a public compensation for victims, because this is one of the things that has to be improved in the legislation in Spain relating to this specific kind of victims, sexual kind of victims.
Thank you, Cristina. Also, we have a new question. Maybe some of the answer may include this answer. What crime is? The question is, in sexual crimes, there's a problem of proof. So the question is, for sex crimes against women, are victim and witnesses' statements enough for conviction? This is the main problem in proving in sexual crimes, because most of the time a victim statements appears only unique evidence in the courtroom. Biological evidences are lost because a victim may have a shower, and so in many occasions, so it is very difficult to find proper evidence. So how is the situation in your country? How do you tackle with this problem?
I would like to also state that in case of non-consensual rape, it's even more difficult because biological evidence is actually, no one contested that it happened, but the perpetrator said it was consensual and the victim said it was not. So it's adding a factor of difficulty to our job. And I think it will be pretty interesting to see how Sweden, how Greece will go on with this, and how will actually be when and how an offender will be convicted. That's something that I would like to add.
Thank you, Cara. And Spanish colleagues? Then I turn Serbian colleagues. And Spanish colleagues, Raquel, Cristina, what would you like to say? Or you don't have any?
Yes, I don't know if Raquel wants to say. In Spain, the statement by a witness is enough for the conviction of a perpetrator. It requires some kind of, for example, the consistency of the complaint, the verisimilitude, that it could be possible in the reality world, and also not have that the victim witnesses doesn't have any kind of bad grounds to report. Right now we have like a very new case law with a very important judge, Vicente Magro Servet is the name, with a very interesting 11 requirement to analyze the statement by a witness. But yes, it's enough for the conviction.
Okay, thank you, Cristina. And Professor Gasmi, would you like to say
in
something?
Serbia? Thank you for the question. In Serbia, actually, the statement of the victim is enough, but we also in practice are using the expertise of the independent expert of the most often cases actually engaged by psychiatrists in cases of very difficult and aggravating circumstances of sexual violence, and also the statements of witnesses. I'm reading here, for example, the judgment of the Supreme Court, which is actually citing not only statement of the victim, but also some forensic documents and statement of witnesses and the report of the independent court expert. And the most important actually is the statement of the victim considering the perpetrator. That the problem in giving proofs here, we actually in practice ask for, I mean, judges are asking for use of threat and coercion and force. So we still do not have that kind of practice like in other countries, how to prove the absence of consent. Although a very influential NGO is asking for modernization in line, of course, with Istanbul, but we have very modern procedural law and other aspects of prevention of re-victimization are used very widely. Thank you.
Thank you so much, Professor Gasmi. I guess all of the questions are answered, and all of our speakers have uttered their opinions, and thank you so much. We are almost at the end of our session. I just want to wrap up what we discussed today, and I just would like to go through some important points we discussed today. Professor Gasmi showed us the importance of Istanbul Convention. It is a huge relation with criminal justice system and this 3P issue: prevention, protection, punishment, and other correlated policies. And it gives us a holistic approach to tackle with this public health issue, which is called this is infringement of women human rights violation, domestic violence, and similar behavior. And it is a monitoring mechanism, which is also very important. And one of the most important aspect what Professor Gasmi told us, this convention is not some words on the paper, but it has a function. It is a de facto also has a function and meaning in the real life. So this is the important, one of the most peculiarities of Istanbul Convention. And secondly, Chara, our colleagues from Greeks, she showed us the rape issue from the Istanbul Convention and Greek application. This is also very important. And also she discussed a lot, it is details. And thank you so much. Also explain us difficulties in these rape cases. And our colleagues, first colleagues from Spain, Raquel Blázquez, she showed us protection order implementation within the European Union, how these measures, interim measure, which is also called protective measures, implemented in the European Union. Like in Germany, it is implemented by family court, like also in Turkey. In criminal justice system, it's implemented in Spain example. So it was also very interesting for us. And lastly, the fourth colleague from Spain, Dr. López, she explained us very comprehensively victim rights in the criminal procedure with regard to European Union directive, and also from the Istanbul Convention, and also with Spain national law system. It was very comprehensive. Thank you so much. I enjoyed this session a lot, and it was very fruitful. Thank you so much.
Thank you so much.
Thank you.
Thank you
for the invitation.
Yeah, it was a great honor for us to have you. It's in such a meaningful day. You all had put a lot of effort in this domestic violence, gender-based violence. Thank you so much.
Thank you.
Thank you.
Thank you.
Bye.
Goodbye.
Bye.